There we go. So the topic for today is going to be something different. I've done a couple of vlogs since I started my channel a few years back. I remember my first vlog was why you need to always fight your DUI, and my second vlog was something else related to DUI law. Now we're going to talk about lawyers generally, and specifically the topic for this video, this is vlog number 3, why you should hire, not just should, why you need, and I would even go so far as to say must, hire a trial lawyer. And the reason for that is because, well, there's a couple of things that go into this. So number one, the majority of lawyers do not try cases. Why is that? Well, you could attribute it to lack of experience, lack of desire, lack of possibly professionalism. A lot of lawyers understand that once they have the client's money in their pocket, there's really no absolute necessity to try the case. Now, the flip side to that is that a lot of clients can't afford to go to trial. Trials are expensive. They are very, they require a lot of work, a lot of hours to be put in order to successfully try a case. Now, again, the flip side to that is that the more a lawyer tries cases, the less time the lawyer will need to invest into preparing a case to go to trial. I'll give you a prime example. The first case that I have ever tried, I think I spent a total of, I don't know, 200 hours, something like that, probably preparing. But that's because I had no idea what I was walking into. I had to start a lot of things from scratch. I had no real materials that I could borrow from, etc., etc., etc. But then as I got to my second, third, fourth, fifth, sixth, seventh, 12th, 15th, 20th trial, you kind of start, you understand a lot of it is copy and paste. Like my voir dire, which is also known as jury selection, is already pre-made. For the most part, it's all copy and paste with the exception of a few questions I will throw in here and there. A trial that is that I'm preparing in 2 weeks, it will take me 5 minutes to prepare the jury selection portion of it. The meat will obviously go into preparing the closing and into preparing the cross-examination of the state's star witness, which 98% of the time in criminal cases, especially in DUI cases, is going to be the police officer who has pulled my client over and later arrested them. So those are primarily the reasons why a lot of cases don't go to trial. Now, there are other reasons. The prosecutor may present an offer that is very reasonable, and settling the case is more prudent than taking it to trial. So let's say there's 5 or 6 charges, DUI being only one of them. There may be a felony attached to it, such as a wanton endangerment first degree if there was an accident and somebody suffered injuries in the accident. You definitely want to act in your client's best interest. So if you don't take the deal, you're going to end up in circuit court and you're going to be litigating the case, and now your client is looking up to 5 years in prison rather than 30 days in jail, which is the maximum in a DUI first offense in Kentucky. So if the prosecutor is offering to dismiss the felony or amend it down to a misdemeanor, such as a wanton endangerment second degree, and let's say to dismiss 3 or 4 of the other charges as long as the client takes the DUI and the one, or just the DUI, well, then it's obviously a lot more prudent to take the deal in those cases. However, in my experience, and I've already talked to and received enough phone calls from individuals throughout my career where I look at the facts and the client has already pled guilty. They may be looking for an expungement. They may be looking for a second opinion, which is already too late since the plea has already been entered. and attacking a plea once it's already been entered by the court, especially with the assistance of counsel, is one of the most, if not the most difficult thing other than habeas corpus petitions, which we do not capitalize on in the firm. So I'm quite unfamiliar with those personally. But once a guilty plea is entered, attacking it on its face, it must be voluntary, intelligent, and knowing. So if you can prove that the plea entered was not voluntary, intelligent, or knowing, then you're going to be able to overturn the plea. And like I said, it is the hardest thing that you can possibly conceive of in the legal system. If you're unrepresented, it's still possible, still very difficult. If you're represented, consider it impossible, in my opinion. So I get a lot of these calls. Clients call me and they say, look, I pled, my lawyer told me I should plead, but I want to see if there's anything that you can do. And I'm just for out of curiosity's sake, I will open up the citation, I'll read it, and I will flat out in my head go, this is a winnable case. I could definitely, knowing these particular facts with these particular this particular scenario with this particular client, I think I can win. Now, I'm not saying I would, but I'm saying I've encountered this scenario countless times at this point in my career, and it's sad, it's unfortunate. And again, there could be a myriad of other factors. Maybe the client couldn't afford the fee. Maybe the lawyer was not a trial lawyer and just wanted to pocket the money and call it a day. It could be a slew of different reasons as to why that particular lawyer did not try that particular case. But basically, I'm circling back to the purpose of this video is to let you all, the public, the lay people of the world, to ask your lawyers, the one that you have hired for your case, have you tried a case before? You will be amazed, and that's a very big red flag. That is literally red flag number one. If they say, oh yeah, I tried a case 20 years ago, or I've never tried a case, they may not admit it to you directly like that, but if you put them on the spot, I mean, I highly doubt that they would directly lie to your face. Yes, I try cases all the time, when they really don't, because now they're putting their career in jeopardy on many levels, and their truthfulness and veracity of their personhood now becomes questionable. Especially if the truth comes to light at any point later on, which it will. So you want an attorney who tries cases. Why? A lot of clients believe that if you fight your case, things will get worse. And that is true if the attorney that you have hired is not a trial lawyer. Because when they start fighting your case, and this is the first case they've ever fought in their entire career, guess what? The prosecutor is going to start threatening that lawyer. Hey, you want to fight this one? The next 100 cases you have with me, I'm going to give you crappy deals on. And what do you think that lawyer is going to do? Well, I don't want to sacrifice 100 of my cases just for this one client. So how about we simply go into making a deal as quickly as possible because, oh dear God, I do not want to piss off this prosecutor. And you'd be amazed how many times that happens in the courthouse. So if you have an attorney who regularly tries cases, not only are they already better suited to represent you, there is nothing possibly negative that could come out of the situation rather than it already unfolding as it would. Let me explain. So I would go in, talk to the prosecutor, realize this is a potentially triable case, try and get a reasonable offer, maybe try and get the DUI, for instance, amended down because I have great facts and I think I can win. And the prosecutor is not willing to do anything. And maybe I have a suppressible issue, an issue for a suppression hearing, that is. And the prosecutor will threaten me. It may say, well, you set it for a suppression, the deal is off the table. Fine. That's okay. Let's go ahead and set it, and then if we win at suppression, now the prosecution's case is crippled. Now we are at a better footing, and now the prosecutor will not only come back with the offer, they may come back with a better offer, because now the court has crippled their case. Let's look at the flip side. The court rules against us. The deal is off the table. Now we may be able to try the case. And again, you'd be amazed. amazed how many times the morning of trial, the day before trial, prosecutors, when they finally, it dawns on them, wow, this lawyer really is going to go to trial on this case. And they finally start to realize that, wait a minute, I'm not dealing with someone who's just bluffing, because reputation will precede the lawyer when they come to a different county where they may have never been in before. Once the prosecutor realizes who the lawyer on the case is, if they know them by reputation, you'd be amazed at how often that happens. Once they realize that this attorney really is going to try the case, some of them will buckle 24, 48, 2 hours before trial. Not saying it will happen in every case. Obviously, as you can see from my YouTube channel, I have quite a few trials where the prosecutor has gone all the way to trial and then either won or lost. So if you hire an attorney who regularly tries cases and is known as a trial lawyer, a trial attorney, you are better off. Now granted, they will be more expensive. There's no soft way of putting about it. You get what you pay for. We've all heard that. And if you're paying $300 for your DUI case, you can imagine what type of representation you're going to get versus hiring someone who you're paying $3,000 or $6,000 or $15,000 for. It is imperative for, in my opinion, to hire a lawyer and to ask questions at the intake, at the first meeting with the lawyer. Do you try cases? How many cases have you tried? Now, don't ask how many have you won, okay? That is not a smart question to ask, and here's why. If they're already trying cases, they're probably winning. So that's probably a given. If the lawyer has tried 20 cases and lost every single one, could be for a slew of reasons. They may be a public defender and they have no choice. They have to try the case and they're all loser cases. I've seen that countless times. It is maybe not in a row, that's an exaggeration, but you get the idea. They don't pick their clients, and the clients do not pay them money. And if the client says, I want to go to trial, look, you're looking at 15 years to life here, buddy, I don't care, I want to go to trial, they're going to go to trial. There is no question about it. And even if the facts are disastrous and they lose, well, you know that the lawyer has done everything they could in their power to save the client from a life imprisonment, but the client was not willing to take any type of deal. They thought they were innocent, their innocence would be proved, and it never happened, so they go to jail, and they were found guilty. But short of that, asking a lawyer as to how many cases they have won is misleading because, well, there could be a couple of things. Number one, if they're a young lawyer and they've only tried like 4 or 5 cases, but they're trying. Pardon the pun here, but they're trying cases and they're trying to try. You know what I mean? If they're putting forth the effort, that already means volumes to you as the potential client who's about to hire this attorney. And now, as I've said, the flip side to it, if they've never tried a case, that's a huge red flag. Not saying it's a guarantee. They maybe they know the prosecutor very, very well and they can get you a deal that I would never be able to dream of. Lots of dealings in the courthouse amongst lawyers in that respect. But if you're truly determined to win your case, you need to hire a trial lawyer, a lawyer that tries cases, makes an effort to win. Like I said, they will be more expensive, but you'll be better suited because there is nothing the prosecutor can do or say to scare, if you will, or frighten or threaten the lawyer into taking that plea deal. Because the lawyer knows, worst case scenario, I'm going to put 6 or 12, if it's a circuit court case, 6 if it's a district court case, men and women in the box, in the jury box, and they're going to be deciding my client's fate. They're going to be deciding your fate, not you, prosecutor, not you, the judge, unless you're going for a bench trial, which in my cases, those are rare. I usually opt in for a jury, because then the community gets to decide the fate of the individual. And in my years of practice, and I will say this is coming from the heart, it is sad. It is utterly, utterly sad where there's so many cases that can, I feel, easily be presented to a jury. Easily. with good facts, facts that support innocence. And how many times have I seen this in this courthouse? Well, if the jury convicts, they're gonna give you the maximum. They're gonna give you a year in jail. They're gonna give you 6 months in jail. It's a scare tactic that lawyers use. Some of them, not all of them, of course. Very few, thank God. And the client trusts the lawyer. They say, oh my God, I don't want to go to jail for 6 months. Okay, let's take the deal. And I'm standing there thinking, no, I don't even know the facts, but I know that you have to really, really, really screw up for the jury to want, because I've lost my fair share. And once you practice enough, once you understand how jurors think, how they approach cases, how they analyze cases, because they're human beings. You're talking, this is not a computer-generated algorithm where you input data and you get back 3 weeks jail or 6 months jail or 1 day jail. These are human beings who take into account every facet of the case, whether the individual is married, has children, has a career, operator's license, if they're a CDL driver. I mean, all those things. Again, specifically I'm talking about DUIs because that's my specialty, but you get the idea. So jurors are human beings. They're living, breathing creatures, and they know that they're given the momentous task of, number one, deciding guilt or innocence. And most importantly, number two, if it's guilt, they get to decide not only guilt or innocence, which is a hard enough task in and of itself, they could get to decide penalty. And the penalty could range, again, from 0, which in the few cases that I've lost, most of the time, my clients do not go to jail, even when we lose. The 1 or 2, I could give you, this would be a topic for another video, I think, but I could even give you the reasons why I think the jurors that gave my clients jail time in those particular cases, I know exactly why the jurors gave those 2 clients jail time. I've had 2 clients that actually got jail time after they were convicted by a jury. Since I'm already on the topic, might as well. One appeared very cocky and condescending and sure of himself on the stand, and that's why the jurors didn't like that, so they thought to teach him a lesson. And the other one, that was my very, very, very first case. I should never have taken it to trial, but the client paid me. He was a CDL driver. He said, we need to go. And there was not an accident, but there was contact between his vehicle and the cop's vehicle. For various reasons, but there was that, and the jurors just did not like that. So in both scenarios, so unless my client deviates from my suggestions as to how they should appear in front of the jury, then they run the risk of going to jail, like that individual who was cocky. And I told him, he was a smartass. And I told him, by nature, I told him, whatever you do, just don't be a smartass on the stand. Don't do it. It's not worth it. Even if we lose, there's still no guarantee you're going to go to jail. You're going to be fine. But he did not listen to me. And instead, he was cocky and condescending and tried to play off this hard ass who was going to be, And the jurors didn't like it. And they're like, you know what, buddy? Here you go. Because the facts did not merit jail at all. At all. But he got 10 days in jail. So, again, in the cases that I've lost that did not merit jail time, except that one, for a jury to lock an individual up in the penitentiary for the crime that they have committed, there has to be a specific set of facts to merit that. And only a trial lawyer will be able to determine that, as I now know, being one myself. So having that experience, having that skill, I now can a lot more effectively advocate for my clients, because when they come to my office and I look at the facts and I go, you know what, I think this can be won, and in my head going, even if we lose, the client is not going to go to jail, because these facts are do not merit jail time. And I've proven myself right time and time and time again. So when a lawyer, the next time I'm at the courthouse and I hear another lawyer trying to scare their client, well, they can give you up to 30 days in jail if you don't plead to this, I'm thinking, maybe, but probably not. Because when they're in the really, really bad cases where there's an accident and there's injuries, God forbid, yeah, those cases, to try them and win would require some very serious legal and oratory finesse. But short of that, I honestly am starting to think more and more and more as I'm getting better and better and better at this, pretty much every single DUI case can be tried, win or lose. And I'm encouraging more and more clients. I think I have, I tried, how many cases did I try last year? January, February, March, May, August, October. I think I tried 6 or 7 cases last year, definitely 6. I think there's a 7th one in there that I'm missing. And I've already tried 1 case this year, and I was supposed to have a couple more, but both of them got pushed. I have about 8 cases set for trial between now and May. And you can bet most of those will go, and I will be trying pretty much all of them. And I have at least 3 more in the pipeline. So this will probably be the most trial-heavy year I've ever had in my entire career. Again, for a few reasons. 1, I have clients who can afford it. 2, I have more clients, so that means I can find more clients that can afford it. 3, I'm getting better and better at this, so I'm able to try cases that are more closer to the line of loss and victory. So all of those factors are factors, and they do play a role in the determination process of whether or not the case can go to trial. And don't forget, there's the flip side of, sometimes I tell the client, hey, we can try this case and win, and they don't feel comfortable and they don't want it. They're scared. To them, trial is a lot of pressure, not just for the lawyer. Trial is a lot of pressure for the client as well. It's nerve-wracking. It's stressful, and clients are people. They have jobs, they have families, they have kids, they may have grandkids, and so on and so forth. They have hobbies, and a lot of those things get put on pause. And trials sometimes get set out 3, 4, 5, 6 weeks, 2, 3, 4, 5 months in advance. So I can understand why a lot of clients would not want to go to trial. Again, to circle back to the main point, ask your lawyer at the first intake, before you hire them, do you try cases? How many cases have you tried? If they're a young person, been a lawyer for 3 to 5 years, if they say I've tried 5 cases, that's fine. If they've been practicing for 40 years and they say I've tried 2 cases, you got a problem, in my opinion. So I think it's important. I think it's a question that should be asked. And in my experience, the clients who come to me, let's say out of 100 clients, 1 will ask that question. 1 client will ask, do you have experience in trial? So about 1% of clients who come to, not necessarily hire, but for the client interview, for the intake, whether or not to hire me or not, 1%, probably less than 1%, actually ask the question, do you try cases? And that's wrong. Every single person who comes into my office should be asking, 100% of clients should be asking, do you try cases? Because that is the hallmark and the difference between a lawyer, that is the hallmark and the difference between a good lawyer and just a lawyer. That's my suggestion for vlog number 3. I wanted to thank you all for joining me here. We wanted to do this outside like I did the first 2 vlogs. It's gloomy, cloudy, and snowing outside, so that is why we're doing it indoors. So again, I wanted to thank you all for joining. Don't forget to like this video, comment below, drop your comments in the boxes below. Subscribe to my channel if you haven't already. Hit that little bell so you get notifications when we go live. We got a lot of content in the pipelines. I'm not sure when this video will air. This is February the 8th of 2020, but we have my trial from January that's premiering tomorrow at noon Eastern. We have our podcast that's premiering Tuesday at 8 p.m. That's our first episode. And the live stream that's going to start in a few hours here that I'm going to stream. So you'll see the same attire, if you will. And we have another episode, live stream episode, coming on February the 15th at 6:30, in which we're going to discuss what to do if pulled over by a police officer. That topic has been highly requested, so I'm finally doing it, and I think that's going to generate a very, very, very strong viewership. So I look forward to doing that, and I look forward to seeing you all in the next video. Bye, everybody.